All right, let's move on to raising capital in the context of the partnership. Same basic concepts that we went over when we discussed raising capital in the corporation and raising capital in the LLC. There's equity financing and there's debt financing. Equity interests in a partnership, as we know, are called partnership interests. So if I have an interest in a partnership, it is called a partnership interest. Let's talk about equity financing in the partnership. A partnership interest has control rights and economic rights. You should be very familiar with what these terms mean. Let's discuss what they mean in the context of the partnership. What are the control rights of partners? Well, partners have direct management rights. They also have voting rights. Very similar to the LLC. Each partner has a right to participate directly in the management of the partnership's business, right? Except for the limited partners in a limited partnership. Remember what a limited partnership is? Limited partnership has general partners and limited partners. The general partners are active. The limited partners are passive. Now, this is the default rule for the partnership. Equal rights to management without regard to investment or capital contribution to the partnership. You may change this default rule in your partnership agreement. What are the voting rights of partners? Well, voting is per capita, not based on percentage of capital contribution. Once again, you may change that in the partnership agreement. What are the economic rights of the partners? Let's talk about sharing profits. Remember, we talked about sharing profits in the corporation, and sharing profits in the corporation is based on proportion of shareholdings. So if I own 25% of the if I own 25% of the issued and outstanding shares of the corporation, then I am entitled to 25% of the profits. Partnership is different. Partnership, profit sharing is per capita. Each partner will share equally in the profits without regard to capital contribution. So profit sharing is not based on the proportion of capital contribution to the partnership. You may change this in your partnership agreement. And you might indeed want to change it. If your client is in a partnership and is contributing the vast bulk of the capital to the partnership, your client might want a greater say in the partnership matters. And so she would want a greater voting right. She would not want to share voting rights equal with the other partners who might have contributed much less to the corporation, to the partnership. Let's talk about sharing losses. Now, the default is that the parties will share losses equally without regard to capital contribution. The parties may change this in the partnership agreement. It's the same basic idea that we saw in the LLC, except this really means something for the partners because the partners bear the risk of personal liability. Remember in the LLC, sharing losses was really only an accounting matter because the members in an LLC are protected with limited liability. But the partners of a partnership are not protected with limited liability. Therefore, when we talk about sharing losses, this becomes very important. It's more than an accounting matter. No matter how you agree to share losses, whether it's the default rule, share losses equally, or if the partnership agreement changes that default rule, this is not binding on the partners, on the partnership's creditors. If the partnership cannot pay off its creditors, if the partnership cannot meet its obligations, the partners are personally responsible for it, and they're jointly and severally liable for the partnership's obligations. In other words, one partner can be liable for the entire amount. So for example, if our partnership cannot meet a $100,000 obligation, I am only one of the partners, but the creditor can come to me and get judgment from me alone, regardless of how the other partners and I agreed how to allocate losses among ourselves. Once I am liable and there's a judgment against me for that $100,000, I can seek contribution from my other partners, but that doesn't bind the creditor. The creditor is entitled to the entire $100,000 from me. All right, let's talk about partnership capital accounts. Right? It's the same as the same as what we discussed in the LLC with respect to capital accounts, but capital accounts mean something here because if your capital account is in the negative and it's a partnership, you are personally liable for that amount. So, for example, imagine a member's capital account balance in an LLC is in the negative. And in accounting, when you put something in parentheses, it means it's in the negative. So in an LLC, we have a member's capital account balance, and it's negative $10,000. What does that mean? Well, it means almost nothing. It just means it's the equivalent of zero capital balance because the member is protected with limited liability. But if a partner's capital account balance is negative $10,000, that means the partner is responsible to contribute $10,000 if the partnership cannot meet its obligations. So this negative $10,000 capital account balance from the partner is significant because the partner is not protected with limited liability.